Appearances. May it please the court. Lee Patel Nishihara of NRL and Associates appearing for Ms. Lillian Zhang, the applicant in this matter. Your Honor, the presentation structure today will be as follows. I will present a brief but broad opening of the issues in this case of both fact and law, which need to be determined. Mr. Lee will advance our arguments in favor of the orders sought. Mr. Patel will then conclude our submissions in the closing statement. May it please the court. Freezing orders are described as the law's nuclear weapon. The applicant would like to acknowledge that the case presently before the court strikes those issues at the heart of the administration of justice and equity. However, I assure Your Honor that this application for a freezing order under Chapter 10, Part 2, Division 5 of the Uniform Civil Rules, specifically Rules 112.13 to 21, does not intend nor will it cause any harm. On the contrary, the freezing order, if granted, will further the interests of justice without upsetting the balance of convenience. I represent Ms. Lillian Zhang, an olive grower who has an ongoing case against Res Irrigation. Unfortunately, the affidavit evidence shows that the respondent intends to immediately depart from Australia with all its assets. This is beyond mere suspicion and is not in the ordinary course of business. Any judgment made on the dispute concerning faulty irrigation will be frustrated, unsatisfied, and rendered inconsequential. It would deny our remedy and defeat the rule of law. Given the exceptional facts of this case, only a freezing order is appropriate. We establish a prima facie case on the affidavit evidence. The first two limbs of the test employed in Taylor and Diamond, 1997, Volume 6, Northern Territory Law Reports, page 164. Your Honor, may I dispense with formal citations? They are satisfied because we can infer from the affidavits that the ongoing dispute has sufficient merit, and the respondent's assets outlined in Res's affidavit and paragraph 2 of our outline of argument can be subject to a freezing order. Accordingly, it is the third limb that is in dispute, namely the risk which must be proven sufficiently real to become a danger of asset dissipation. The respondent's financial position raises legitimate concerns. For example, the proceeds of sale are to exclusively finance overseas activities. There is limited and unreliable evidence regarding the extent of funds necessary for Res's overseas operations and their actual prospects of success. Therefore, I submit no prejudice will be suffered by Res if its assets are partially frozen. Additionally, the feeling of extreme unease, compounded by the lack of evidence addressing the details and financial ramifications of proposed arrangements between Res and its future South Australian branch, together with the balance of convenience and other discretionary factors, should favor granting the order. Similar facts were considered in Taylor and Diamond, in which the order was granted. The legal issues are as follows. The standard of proof of the third limb is lower. Shazia's affidavit prima facie proves aspects of Res's prior conduct and casts doubt on their ability to preserve assets. For example, there has been disposal of assets at undervalued. There have been incidents in business methods suggesting that Res may be unreliable. Given the manager's concerning credit record, there is a real likelihood of default. In fact, the manager's threats to escape judgment should be given greater weight because unlike the facts of Osbro and Mayer, the danger here is apparent. While subjective intention is not required, its presence can enhance the objective test of effect. Overall, Shazia's affidavit suggests that Res cannot be trusted to use its funds freely. Ms. Alexandra's affidavit shows Res's clear intention to move all its assets overseas. The liquid assets will be easily spirited away. A freezing order was granted in Cummins and Pathline, where easily removable liquid assets constituted the entirety of the respondent's assets. Because liquid proceeds facilitate dissipation, where possible, the order should prevent the sale of properties unless the balance of convenience requires otherwise. The issue of One Warehouse Road, co-owned by Barry's Drilling, will be considered in the closing statement. I finish by saying that the applicant will gain no proprietary interest or security. We are not concerned with protecting RES's assets from commercial risks and losses. RES can still meet prior liabilities and ordinary living expenses and even take out loans. There will be no restraint of liberty to travel overseas. We provide undertakings to pay any damages and bear responsibility for any harm via the usual undertaking as to damages. If granted, the order may contain ancillary orders to ascertain the exact nature of each asset so that only the minimum amount necessary is frozen, and the respondent can still use the remainder to undertake its overseas activities. RES's affidavit is suspected not to have fully disclosed all the assets. Therefore, it is too early for the applicant to specify which assets to freeze. These common law principles have been summarized in the freezing order protocol in Schedule 3 of the Uniform Civil Rules. Thank you, Your Honor. Mr. Lee will now continue the submissions.